Welcome to edisati.com, your partner in education. In this session, we'll discuss the concept of legal vocabulary. Legal vocabulary is a very important part in your law entrance tests, and you may get 4 to 5 questions based on the synonyms of any of the legal terms that is given to you as the question. Now, please be assured that you understand that legal words have very pertinent and specific meanings. You cannot generalize these terms and try and estimate the answers. If you try to do so, you may end up giving the incorrect answers. The reason for this is very simple. The legal system of India was adapted from the Britain. And since they have an influence of foreign languages over their constitution, thus we also use such words which are of foreign origins. Generally, you may find these words and a list of these words termed as migratory words in your books. Now, what exactly happened is that Latin words were adapted in the Constitution of Britain, and since then, even we have adapted those Latin terms as a part of our legal terminology that we use in India. Thus, legal terminology has an influence of Latin, not as much as the other languages, but yes, Latin has a very, very significant impact on the legal terms that are used in India. To memorize these words, it becomes quite tricky because we are not very adept to use of Latin language. So in this session, what we'll do is that we'll break the basic word roots and we'll learn about the word roots that are used in Latin language, and we'll try and interpret how can we memorize the words, the legal words, by the knowledge of or by the awareness of these Latin word roots. Now, please be assured that a word root might mean something else in the normal vocabulary and it might mean something else in the legal vocabulary. Time and again, I'll just like to inform you that legal terms have different and specific meanings. They cannot be estimated or guessed by the knowledge of our normal English vocabulary. Legal vocabulary is a very specific and different language in itself. So let us start our discussion from the word root a. A means from. So any word that has a in its as a prefix, it is basically it means from. For example, it's a fortiori, which means from stronger. Now, let me give you an example to let you understand what we mean by a fortiori. For example, Bob is any guy who is applying for a certain examination, and he has a younger brother as well. So let the younger brother be called as Alex. Now, Bob's age is 20 years, whereas Alex is 3 years younger to him, so he's 17. And the minimum age criteria of entering or applying for the examination is 21. Right. So, Bob is not eligible to apply for the examination. So, we can say that Alex is not eligible to apply for the examination a fortiori. By what I mean is that since we have a stronger reason, that is, Bob is not eligible, and this is very imminent, thus, it is very imminent that Alex will also not be eligible to apply for the examination. Why? Because he's even younger than Bob. So, Alex is not eligible to apply for the examination a fortiori. That is, it has a very stronger reason attached to it, from a stronger reason, which is that he has an elder brother who is not eligible to apply for the examination. So, if we have anything that has a stronger reason attached to it, we say that the reason is a fortiori. Another word that has the prefix as a is a posteriori, which means from later. And another word which is a priori, which is from earlier. A priori means from the earlier knowledge or from experience, and a posteriori means from observation. So a priori means from experience, and A posteriori means observation. For example, we say triangle has three sides or bachelors are unmarried. This information or these facts are the examples of a posteriori. This is what we observe actually. Like if it's a triangle, it has three sides, you know. There are three sides. You can count one, two, three. Since it's only three sides or three angles into it, so it is known as a triangle. So this is something that we observe, we have read in theory, and since it's theoretically eminent, or we have observed that, it becomes a posteriori. A priori is when we have got an experience of doing something, and again you're replicating that experience. You have an experience, like for example, if I do not study, I'll fail in an examination a priori. I can say this a priori, right? This is why, because might be I did not study in an examination and I failed it. Or I saw somebody who did not prepare well or did not prepare at all for this examination and he failed the examination. So I have an experience of this very particular event, and since I have that experience, I know or I have a knowledge about this, so that sort of knowledge is a priori. So the basic difference between a posteriori and a priori is that in the cases of a priori, the knowledge comes from our past experiences, whereas in the cases of a posteriori, the knowledge is based on our observation. Another word that uses the prefix of is equo, which means from which. Now, for example, I say the court equo or the judge equo, which means that the court from which, that is, supposingly a case is being referred from the lower court to the upper court, the upper court would say the court quo means the court from which we have received this case says so and so, or the judge quo means the judge from which we received this case has passed the judgment in the so and so manner. So quo is used for referring for the referential purposes in the legal terminologies. As like ab or ab also means from. For example, ab extra, that is from outside. Right. For example, I know about this event ab extra. That is, if there's a group of friends and we are discussing about something, I'll say that I know about her ab extra. That is, I know her from outside. That is, somebody else might have met me. I know her through somebody else or something like that. Likewise, we have ab initio, which means from the beginning. The best way to memorize initio is that it is somewhat homophonic to initial, which is the starting point, right? Initio stands for initial, which is the starting point. So ab initio means from the beginning. So if there's a contract which is void, and I say it's void ab initio, this means that the contract is void since from its very beginning. It cannot be enforced. Why? Because the agreement is void ab initio means that it cannot be enforced because it has certain errors, certain fatal errors, which do not let it to be enforced. Right? So ab initio means from the beginning. Just like eb means from, ed means to. So any word that has prefix as ed has certain relation to. For examples, ed coelum, which is to the sky. Now, ed coelum is generally used in the cases of property. Now, for example, there's some land and the owner has its proprietorship ed coelum. That is, the air above the land is also owned by the owner. I'll give you an example to let you understand this better. Now, for example, there are two houses. One is this and the other is here. And this house probably plans to implant such a structure which is entering into the, the arena or the space of the other house, right? Now, this person, the owner of this house, can sue this person. Why? Because he's obstructing the air flow or the air that passes or that floats through this house. So supposing this is house number 1 and house number 2. So the owner of house number 2 can sue the owner of house number 1. Why? Because he's obstructing the air of house number 2. And the basis of the case would be that he might say that he is obstructing or he's this is trespassing ad coelum, which is that he is basically entering into the air that I own over my house. So ad coelum is basically the term that specifies or means that the air above the ground belongs to the owner of the ground. Likewise, if I talk about something that is underneath the ground, again, that belongs to the owner of the ground. Now, this might confuse you that if somebody digs uh, any pit in the ground and finds certain amount of gold or any prestigious item, then what happens? Well, in that case, although the ground belongs, since the floor belongs to the persons, and so does the ground underneath it, ad coelum. But in that case, the government is more liable to get that entire gold. But he'll be rewarded with certain or the other thing, which you're gonna read and study in the next certain few other legal lectures. Let's move further. We have ad hoc, which is to the place of or for this. Now we have ad hoc judges or ad hoc teachers. For example, Mrs. Sinha has been appointed as an ad hoc geography lecturer in this college. This means that she has been hired on the temporary basis in the place of an other permanent teacher, right? So for example, there's some teachers, say Mrs. Sharma, she's going on a maternity leave and she needs to leave. So, and we've hired Mrs. Sinha in place of her to serve in the place of her. So Mrs. Sinha is coming to the place of or to fill the place of Mrs. Sharma. So she is an ad hoc teacher. Next, we have ad hominem, which is at the person to the personal character. If somebody is passing some derogatory remarks or he's disparaging you, you can say his remarks were ad hominem, which means he was attacking on the personal character. We have ad idem, which is to the same thing. That is, everybody agrees on a very simple and plain, or there's a unanimous decision. So everybody agrees on the to the same thing. Generally, it is used with consensus, and they say the entire word is consensus ad idem. Consensus ad idem means everybody has passed a unanimous decision to the any problem or any situation, right? So consensus ad idem is that everybody agrees to the same thing or same point. Likewise, we have ad infinitum, that is to the infinity. Now, for example, a law is being enforced, we say that it will be practiced ad infinitum, which means that it will be practiced to the infinity. Something that is that continues forever. It flows ad infinitum. Ad litem, that is for the case of or to the party. Now, for example, there's a case between Ram and Sham, and Ram is crippled. He cannot come over to the college or to the court, sorry, and he's hired another person, say Bobby, who's gonna come and represent Ram in the case. So he is representing Ram for this very case, for this same very case, and he's representing one party. So he's representing ad litem. Right. So for the case, if somebody is representing one of the parties, say to be plaintiff or defendant, that person is referred, he's being hired ad litem. Likewise, we have ad quod damnum. Now, for example, if there's an accident and everybody, like, there's some damage, how did the insurance companies like, how much do they pay? How do they decide that how much to be how much to be has to be approved as the claim that has to be given to the customer of the car? They decided ad quod damnum, that is according to the damage. Now, please note that damnum stands for damage. Right? So damnum stands for damage. And ad quod damnum means according to the damage. That is, if supposingly the two cars just, they banged into each other, and now one of the person has approached the insurance companies that please check that how much claim do I get. So they'll just analyze how much damage has happened to the car, and they'll pass the claim as per that very damage. So that becomes ad quod damnum, right? That is according to the damage. Next, we have ad valorem, that is according to the value. The people who are a little adept to the knowledge, or they have a little much knowledge about the taxation in India, most of the taxation happens ad valorem, which is according to the value. I'll give you an example of factories here, that how do they increase the price of any commodity that they're uh, making or they are producing. What exactly happens is that they at every stage of the process, for example, there are five processes. For example, they put the input, and the first stage one, something happens, then another stage, then another stage, and finally they get the output which they sell. How do they decide the value, that what would be the MRP of this output? Obviously, they'll first of all have some cost price. Now there would be certain value added to this input at the first stage. How much value does that cost? Say to be cost 1. Then in the next stage, then how much cost? This much. Then in the next stage again, how much cost? This much. Ultimately, when they get the output, they have the cost price plus the values that have been added at the different stages. So the price is decided ad valorem, which is how much value does this stage add to the output of the previous stage. So the value that as much has it added becomes decides the cost, and this sort of structure is ad valorem. Next term we have as animus, which means intention. Animus comes from anima, which is heart. And you might be aware, or you might have heard it in our vocab lecture, the normal vocab lecture, the word root lecture, that we have words like magnanimous or pusillanimous, right? Magnanimous is magni plus animus, which means big heart. If somebody is magnanimous, is very generous. Likewise, we have pusillanimous, one who is very coward. Pusil is tiny, right? So animus comes from anima, which is heart, right? And here it again means intentions. In the legal terms, it means intentions, somewhat related to heart itself. That I have my heart into it, or I have the intention of doing something that is related. So, for example, we have animus contrahendi, which is contractual intent. For example, I approach you, let us say you are a big financer, and I approach you and I ask you that I have this business proposal. Why am I coming you? Because I have coming to you because I have animus contrahendi, which is I have the intentions of going into a contract with you, right? So animus contrahendi means that I have the intentions of having a contract with you, or we might be that there's a business proposal that you, if you like, you may pass it and you may finance me. So I am there with an animus contrahendi, which is I have the contractual intentions, right? Likewise, we have animus nocendi, which is intention to harm. Now, for example, a thief enters the house, or any person. Let's take an example of any guy who's entered the house of uh, another person because he seeks a revenge. So he entered the house animus nocendi. That is, he wanted to harm the other person. Let us say I want to I seek a revenge from you because you might have given a correct you were a correct witness, and you might have given a correct statement which went against me, right? And I was proved to be guilty. And when I had completed my servitude, I was relieved from the jail and I came out, and then I made a plan and I entered your house. Might be in a in a disguise or something, and I entered your house. And when I'm caught again, then while writing the papers, they would write that this person entered the house of this person, animus nocendi, which means he wanted to harm the other person. Likewise, we have animus possidendi, which is intentions to possess. That is, that you want to have the ownership of anything, that you want to be the owner of, or you want to be the proprietor of anything. So that is animus possidendi. Likewise, we have animus revertendi, which is intentions to return. Now, in Latin, basically, animus revertendi refers to the intentions of the birds or the migratory birds which fly to the other nations. Now, for example, there's a migratory bird which has traveled from Canada to India, right? Now, it has come over to India with animus revertendi. That is, after the season is over, it will return back to its original place. I'll give you an example of you going to or you visiting a hotel. You visit that hotel or you stay there in that hotel, animus revertendi. That is, you have the intentions of returning back to your home. You'll never stay there forever. You'll be there with animus revertendi. That is, you have the intention of returning back. As animals, we have corpus. Corpus stands for body. Now, by body, I do not mean a dead body or a cadaver, not at all. Body is the the structure or the entire network. That could be anybody's. Now, for example, we have corpus delicti, which is a very important term. Please note that corpus delicti has been asked in many examinations multiple times. Corpus delicti is the body of the crime. Now, for example, uh, we have a case of Salman Khan and the Black Buck case, the famous Black Buck case, right, wherein he's accused of killing a black buck. And there were other film stars who were also accused in the same case. Name to take the names, it was they were Saif Ali Khan, Tabu, and Neelam, the actress Neelam. Right now, I would say that Tabu was the part of corpus delicti. That is, she was the part of the body of the crime. The people who have done that crime, she was among them. She was the part of corpus delicti, right? Likewise, we have corpus juris, that is the body of the law. Now, please ensure that you know that wherever you find the word or jury, that relates to jury or law. Right? Likewise, wherever you find the word delicti, that means crime. Right. So corpus juris means the body of the law, which is like there are 4 or 5 judges in the panels, and we want to say that this guy is also among that panel. We'll say he is corpus juris. That is, he's among the people who are judging this case. Likewise, we have corpus juris civilis, which is the body of the civil law. Um, and we also have corpus juris genitum, which is the body of the law of nations. That is, it is generally used in the United Nations cases, wherein 2 or 3, there's a case between 2 different nations, right? It's an international court. So therein, the jury members who would be referred as corpus juris genitum. Now, this term is a little obsolete. That's not being used as much. Contra, as we all know, means against. So any word that has contra as a prefix means against. For example, we have contra bonus mores. Did you know that bonus comes from bene, which is good, and mores stands for moral. Right? So it means that contra bonus mores means against the good morals. Now, for example, we have the cases of rape. They are contra bonus mores, which is they are against the good morals of the society. Likewise, we have contra legem, which is against the law. Now, please ensure that you again know that legem means law. So, wherever you have legem, that means law. For example, legal system is the law system, right? So contra legem is against the law. Contradicto in adjecto, that is contradiction in itself. That is something that is contradicting itself. It is more or less like an oxymoron. Cold heat. If I use both these terms as cold together, it's a cold heat. Cold is cool, whereas heat is hot, right? Which if we place both of them together, they are contradicting itself. Like, and if I talk it in the terms of legal terminology, I'll say contradicto and adjecto would be uh, any contract that is basically breaching itself. So that becomes contradicto in adjecto. That is contradicting itself. Next, we have contra proferentum, which is against the one bringing forth. The best example to explain you this would be the example of insurance agents, right? Proferentum means it is the ability of one of the parties to sue the other party based on the fact that it has introduced a clause in the contract which is ambiguously stated. Right. Now, for example, in the insurance cases, the insurance agents generally are not very, clear in uh, telling to the party that what exactly are the clauses in the document, right? So the other person might not be able to sue the insurance agent for the cases like force majeure or something, but yes, he can sue him for contra proferentum. That is, he has stated something that is ambiguously written, which has no specific meaning actually. So we cannot understand what do you mean by this thing. So in that case, you can undoubtedly sue the other person if he has stated something in an ambiguous manner in a contract. So contra proferentum is against the one who brings forth. That is, the person who has stated a clause ambiguously can be sued or can be tried in the court for this very conviction.